Good evening, friends. Before our guest of the day, Ms. N.S. Napine, starts her speech, I'll just like to give her an introduction. She's a pioneer in the field of cyber law, and she was practicing in Chennai court and before she migrated to Bombay and thereafter to Supreme Court. And she is practicing extensively in constitutional, criminal, commercial, cyber, and IPR laws. And she was appointed as an amicus curiae by the Honorable Supreme Court in the matter of Prajawala versus Union of India. And she is also a technical committee appointed by the Honorable Supreme Court to evaluate the means to alleviate the problems of child pornography and rape videos that is being circulated online. She is also regularly appearing before Constitution Bench and before the Honorable Supreme Court. And she is an author of the book called Technology Laws Decoded and has received tremendous acclaim. She has authored a manual called Software Piracy for Judicial Training, and she is a founder of Cyber Sati. And with this introduction, I leave the floor to her. Thank you, ma'am. Good evening.
Thank you, sir. Thank you for having me here. With this session, I feel like I'm literally transported to Chennai for the day. So it's a pleasure to see a lot of known faces out there. I gave a very brief session at the Madras Bar Association during the Madras Bar Academy session on electronic evidence. Unfortunately, for paucity of time, I was barely able to commence my address in terms of electronic evidence. So I would like to start today's session by putting some qualifiers. The first thing is that every discussion on electronic evidence seems to begin and end with Section 65B. I understand the importance of it. However, for ensuring that we cover all aspects which are relevant for Section 65, for proving electronic records, I'm going to park the issue of Section 65B till the fag end of the session. I would like to point out the importance of electronic evidence as a field in itself and how much it impacts every kind of litigation or legal proceedings, civil, criminal arbitrations, or before any tribunals or in any form. So it's very important to go beyond just the tenets of Section 65B. And the reason why I'm doing this, and this is an issue which seems to be oft forgotten. Section 65B was a special provision introduced. And I always say this, unless we believe that legislators are some kind of masochists, there is no reason why somebody would introduce a provision to punish us or to punish litigants who are relying on electronic records. It is not by design that this section is so complicated and it makes our lives very difficult. It is by default, it is not by design. So what was intended by the legislator, at least from whatever I can see from the statement of objects and reasons behind the formulation of the Information Technology Act itself and its schedule which introduced Section 65A and B, was that they intended to make e-commerce easier. Their whole scope and purpose was to ensure that electronic commerce transactions will be given legal validity. The problem that seems to have happened is in trying to ensure provisions which will allow for the use of secondary evidence, the draftsman has gone way overboard to ensure that fabricated documents will not be brought before the court. And in that process, a lot of complications have happened. Whilst we are interpreting Section 65A and B, we also have to keep in mind that the provisions have been drafted not necessarily by lawyers or people who are from a legal background. These are from the executive side. So we need to evaluate what is going to be the way forward rather than just looking backwards with respect to 65A and B. However, I do undertake to ensure that I do cover, what all of us as lawyers are familiar with, the questions of who, what, where, when, why, how, which we have to address for any document that we want to rely on in a legal proceeding. So that part of Section 65B, I will definitely go into in detail. I just don't want the session today to be only about 65B. Having said that, let's move forward and let's also start from the very beginning. I always like to say that, that's the best place to start, as the song goes. So when I say let's start at the very beginning, I don't mean to take you all to prehistoric stone tablets, etc. Though in fact, I do have that picture also in hand. Let me just quickly show you all that in the share screen. I don't know if you can see it still, but I'll keep doing this as we go. So as you can see, I do have that also as a picture here, but that's not what I intend to go into today. So let's just start with the process from where it becomes relevant from the legal practitioner's perspective. So I will just share one more slide in terms of what is it that I mean when I say at the beginning, or when we talk about the importance of, the stage in the lifespan of an electronic record, when it becomes important for us to, involve ourselves as lawyers. When you look at this slide, you will see that the first level, which is the incident or the source of the evidence itself, is at the stage of the commission, whether it's a criminal or a civil proceeding. The second level will be involved with respect to investigations. So if you're a prosecutor who's going to be involved from that stage, yes, the second stage is very important. But really speaking, we are coming in from the third stage, depending on when we involve ourselves in a case with respect to electronic evidence. And of course, the last stage in terms of how such evidence is presented before court, and to what extent is it going to be admissible, and to what extent is it going to withstand the test of judicial review, is the final test which we as legal practitioners have to meet. When we talk about this lifespan, and how does it impact us in terms of appreciation of evidence or in allowing it to be accepted, I would like to go to just the 4 principles which the model laws on electronic signatures set out. It was a very interesting mandate that was given for creation of secure electronic signatures, or what we simply call as digital signature certificates. The reason why it is meant to be secure is it captures encryption and the original cryptography processes, and in a manner where, unlike early days of cryptography, I usually give the reference of the original Caesar's cipher, which meant very simply of replacing just some alphabets with numericals. So for instance, if you want to say A, B, C, D, you will just use instead 1, 2, 3, 4. It's a very simple coding of 1:1. There, the person who receives your code already has the key. So they will know that 1 has to be substituted with A and 2 with B, etc. And therefore they could decipher the code. It is the same with Morse code, etc. It's a simple 1:1 translation. We move to a much more complicated situation when we come to something like the Enigma machine, which was used during the Second World War, which needed another Enigma machine for you to be able to decode the message. Alan Turing, the father of computing, is credited with having broken the code, but even, one of the reports state that even for him to break the code, he needed the machine. So without that, it was so complicated that he couldn't break it. The lesson we take away from here is that you need the key for any kind of cryptography, right? So here, when the model code was being formulated, it went into these aspects. That the signature has to be unique to the person. It has to ensure that it cannot be modified, or it will show modification. So the whole reason why you accept a digital signature certificate is because it cannot be modified thereafter, and if any modification to the document wherein you have used your digital signature is done, then it can be identified. And the next two things are very important when we talk about electronic records and reliance in courts, which is they said that the digital signature should be linked to paper, which means that if I have this nice pristine white paper, I'm just looking for a pristine white paper here, and nothing has been written on it, then it is not yet a document. But the minute I even put one dot in this, then it becomes a document. And that dot, even if I erase it, there will be some trail left. And this is where electronic records are better than paper records in terms of proving. Because when I put the dot here, you all in this meeting will be the witnesses to say this is when this document was created. So I will have to produce this document, give evidence as the author of this document, and also substantiate it with further evidence. With electronic records, the advantage that you have is that the logs which are underlying every single electronic record in itself will be valuable in proving when this document was created, who created it, because here the attribution will be to the person who owns the device. You know, that is what the last part is, which is what I was coming to. This one is what I showed as linked to paper. And the fourth characteristic they asked for is linked to person. So when an electronic signature is identifiable with the person to whom it is issued, and that it is linked to paper, that once it is applied, it cannot be modified. Modifications can be detected, and that the signature is so unique that it is non-repudiable, we come actually to first principles. So the first sharing which I would like to do, and today's session, I would like to put it out there that I would prefer the session to be absolutely about sharing and also addressing practical issues and questions that all of you may have, rather than going into a very heavy, academic process. So in doing this, I would just ask you all to do the first thing, therefore, which is we are here to talk about electronic evidence. Yet, I would strongly request you all to please ignore the prefix electronic. Please treat it as just a discussion on evidence. The minute you do that, you will automatically go back to first principles. You will no longer be bogged down with fear that you are now dealing with some kind of a new demon or some kind of a new domain like cyber or digital. The minute you remove a prefix of cyber or digital, you will realize that every single first principle which we have applied time immemorial, definitely when each one of us started practice till date, right? Each of those first principles apply equally to appreciation of electronic evidence. The minute you remove that hurdle from your mind, you will realize that you don't really have to be an expert. I mean, I know this may seem like a counter argument to what I'm stating, but nevertheless, this is the best way to move forward to make the best possible use of electronic records. And therefore, I'm suggesting, one, please ignore the prefix electronic and then start applying first principles to evidence and see whether it applies pari passu to your paper document as well as to your electronic document. The first three ingredients which we would always ensure are these when we talk about proving evidence or giving evidence. And documentary evidence here, I'm restricting myself. One is authenticity of the document. To show that, yes, this indeed is the document which I created, and this is the document as I created, which I'm giving to you. So the second part of authenticity comes into integrity of the document. That I created it and that I sent it or shared it or transferred it or used it in a particular manner, and that from the time of creation to the time of production in court, nothing in the document has changed to affect its integrity. If changes have been made, it is fine. We would then prove the changes also. To give a simple example, the number of times each one of us would have proven original documents which would have some overwriting on it, correct? So for instance, there will be a document that would be shared, a letter sent by company A to company B in the process of some infrastructure implementation. Let's just take it for instance. So after sending the copy to company B, company A would store the office copy with a handwritten note on it stating when this document was sent and in what manner it was received by company B. Similarly, company B, which receives the original, may make an endorsement on top of it saying the date of receipt and by whom it was received. So when we prove this document, we will not only prove the document, but we will also have to prove the overwriting on that document. This aspect of authentication and integrity of this document remains the same when we talk about electronic records. And on this, the law also helps you forward. So if you look beyond what the IT Act and our Evidence Act says with respect to electronic evidence, you will realize that they actually give you the path forward with respect to proving of electronic records. The first and foremost, of course, please remember that when it comes to electronic evidence, you do always have to use both enactments simultaneously. You will find the definitions in the IT Act and you will find substantive provisions in the Evidence Act. It is not like you don't have substantial provisions in the IT Act for that reason. So very, very quickly, I'd like to walk you all through some of these provisions which are going to be very useful for you in terms of a civil or a criminal proceedings. But more importantly, the stage at which I'm starting, if you are representing corporates as corporate counsel or at the stage of negotiation, execution of documents, this is where the relevance comes in at this stage. The IT Act sets out not only about electronic records, electronic data and information, etc. It also talks about digital signatures. Now, when you look at, again, it's always important to go back to etymology to understand where and why not just a new provision has come in, but possibly where some mistakes also could have happened. Now, what happened was when the 2000 Act came out, Information Technology Act here, they froze technology at that time. So they literally just made it into digital, and ignored the larger perspective of electronic. So it was only under the 2008 amendments that digital was replaced by electronic. So whilst doing so, you will realize that in some places, consciously or otherwise, digital would have been retained. So the first leg of it in terms of section 3, what you get is of the digital signature certificates or electronic signatures as they modified it thereafter, which is what we know as the DAC, which every single one of us has. Again, a pause here to tell one of my favorite stories. I told you about the 4 characteristics they wanted, right? Of linking it to person, to paper, uniqueness, and modification. Now, when you look at the linking to person part, and this is what the presumption, which is, if I'm not mistaken, under 85B, brings in for with respect to electronic signatures, and also the presumption with respect to documents which have been signed using electronic signatures is this. Now, the secure electronic signature or your DSC is linked to person based on the issuance of the DSC to a particular person. It is not linked to the person the way your hand is linked to you. Now, I am sitting here talking to you all from my home, but my digital hand is not with me. So all of us are familiar with this one line we always use in every single agreement, right? In witness whereof I, N.S. Napinnai, have subscribed my hand to this agreement on this at Mumbai on this the dash day of dash in the year 2020, right? Now, when I say I've subscribed my hand, the reason is because my hand always follows my body. It's always attached to me. If it is not attached to me, it is not linked to person. This hand is always linked to person. Now, when they gave a digital signature certificate, is it more of a deeming fiction to say that the person to whom the DSC is issued has to take the benefit or the credit of it, and also the responsibility and the liability of it. So if I do not have my digital hand with me, and I have left it with the person whom all of us do that with here, which is to leave it with my chartered accountant, irrespective of whether I am applying that signature or my chartered accountant is applying that signature, it is deemed to have been applied by me. So the presumption works both in my favor and possibly also against me. The reason is that when a rebuttable presumption has been raised, which is that it belongs to me and therefore I take the responsibility of it, the advantage I get is once a document is signed using a DSC, it will be automatically accepted and the integrity of the documents will technically stand proven, unless proven otherwise. But it can also land itself in misuse. I just noted this one case, and interestingly, there are many more similar cases, including from Chennai, in similar fashion, to show how a digital signature can be misused, and therefore, merely because somebody is producing a document which is signed using digital signature, there is no reason for you to presume its authenticity or integrity. It still can be questioned. Now, this was a very interesting case. You know, we hear about warfare without bloodshed. Now, this was a case of a corporate war without bloodshed, or so it seems, except that I would say there is still blood which is shed, which is of the people who were removed from management. So 6 people, let's say, comprise the board, and 3 people wanted to take control of the board. All that they had to do was, using the KYC of the company, they apply for a digital signature certificate. So now you have a secure electronic signature. Then they just use that signature certificate to upload documents on ROC as if 3 of the members of the board have submitted their resignation and 3 new people have consented and they have now been appointed as part of the board. With such a simple process, all that they did was they removed 3 people who otherwise had control over the management and functioning of the company, and took control completely through 6 persons on the board who were in consensus. Now, when this case of DDPL Global Infrastructure Private Limited versus Alok Mishra came before the Bombay High Court, the Bombay High Court realized how easy it was to misuse KYC documents to obtain a digital signature certificate, which otherwise carries such a strong presumption. So a lot of changes with respect to how you now obtain your digital signature certificate, including a multi-factor authentication, which includes a video recording you're supposed to share of yourself, could be well traced to this case. Now, similar cases have come up before the Madras High Court also, and other courts, where, for instance, in one case, a hospital management was taken over using such process. When we talk about these kind of cases, so very quickly, without getting into a very boring section-wise process, but just as a pointer to all of you, please do look at 85. All those A's and B's and C's in the Indian Evidence Act Just go through those. Predominantly, then you will get all the provisions which are relevant with respect to electronic evidence. In fact, after a long time, I opened my book and read the chapter on electronic evidence today, and I must say it did come in very handy for me to put together the presentation for today. So you may look at the provisions under 85A for the presumption with respect to electronic agreements. We'll come to that later. And 85C with respect to the presumption as to DAC, which is what I told you about. And 85B, which is the presumption with respect to electronic records and electronic signature. So when we talk about these presumptions and the cases like the DDPL case, you'll realize that nothing is black and white when it comes to law. And as we always say in cyber security, they, as strong as technology can be in terms of trying to secure your rights. And, a few days back when I was having a session for technology experts and police, the whole discussion factored around the subversion of hash values today. So these are all possibilities that electronic evidence can also be tampered with. But then so can paper documents. That did not stop us from relying on paper documents. So all we have to remember is, one, when a presumption is there with respect to a secure electronic document, it's a rebuttable presumption. Without that, fraud such as these cases would not have been possible to overcome. Moving forward, what happens when you're relying on documents which are not secure electronic signatures, or documents which have not been signed using a secure electronic signature? All that the law says is then that the onus of proving the authenticity and integrity of the document lies with you. So when you're talking about a document which needs to be proven, it may be relevant for you to also rely on this one aspect, which is why I pointed that out with respect to presumption for electronic agreements, and also read with section 10A, which says that mere absence of a signature will not invalidate an electronic agreement or agreement signed using electronic form. And we can then move on to certain issues such as emails, etc. But before we do that, one question came up in terms of reliance with respect to CDs, just before we started this session. And how do we prove what is the content that has been submitted before a court, and whether that content is the same with respect to what may be furnished to us as copies. So one of the first things I wanted to address, and particularly from a criminal perspective, here I will be balancing civil, criminal, etc. to my best possible extent, because these are issues which I believe are things which keep coming up again and again till date. And I am referring to judgments of 2008. Unfortunately, from 2008 till date, not much has changed in terms of prosecutions and charge sheets. So when it comes to the stage of 207 with respect to criminal proceedings, and so you can use the same in a civil proceeding with respect to inspection and discovery process, right? What happens in 207 invariably is that I showed you all the stages with respect to investigation, then court, etc., right? Now, in investigation, electronic records are seized. So the evidence may be in the form of a computer hard disk or an external hard disk, a pen drive, CD, or whatever. Now, whatever is seized, and in fact, it could also be from servers. Now, whatever is seized is then sent for forensic investigation. The forensic investigator's report is filed as a document. But what is seized, the hard disk, computer, laptop, drive, etc., is submitted as an article before the court and not as evidence, not as documentary evidence. So invariably till date, what I keep seeing as a trend in trials is the accused are provided with copies at the stage of 207 of documents such as the forensic report, etc., but not the underlying documents, which is what is relied on by the forensic expert to come to a conclusion. And those underlying documents form part of those various computer paraphernalia which have been seized. The issue came up before the Delhi High Court on whether accused should be given copies of it or not. The first of the case in this list is Dharamveer versus CBI, where the citation is ILR 2008-11 Delhi 842. In most instances, don't bother with the citation. I will try to put it all together in a tabular form and share it so that you will have it on record for your future use. So in Dharamveer, when the Delhi High Court was faced with this question, they unequivocally came up with a response that any document which the prosecution intends to rely on has to be provided. So in Dharamveer, the first level was crossed, which was about should a copy of a CD or whatever be given to the accused or not. And they said that though you may be submitting it as an article, the documents that are there in that resource are relevant, and that is what you have relied on, for instance, in a forensic report, etc. And therefore, there is no question of contesting this request of the accused that all documents that are being relied on should be given to them. A subsequent case of Ujjwal versus State came into the same issue where Dharamveer was also contested, again before the Delhi High Court. And in Ujjwal, the court went on to clarify on an important aspect. Now, we may seize even servers in the process of investigation. So, does it mean that copies of everything should be given to the accused? And how should the copies be given to the accused? Do you have to print everything and then share it with them? You know, there was an experiment, crazy experiments happen all the time, where they said if the contents of one computer is to be printed, including logs, etc., it could cover one football field 3 to 5 stories high. So if this is the status of one computer, imagine if you're dealing with multiple computer resources. So printouts are not going to be viable. So this is where you can ensure one or two things, okay? One of two things rather. One, that you are given a copy. 207, you're entitled to it. Similarly, as a process of inspection and discovery in a civil proceeding, you are entitled to the copy of the electronic records which are underlying a report which a party, whichever side it may be, is relying on. So this is something you can ask for and obtain. But Ujjwal also goes on to say two more things, which is that it can be given in electronic form and it doesn't have to be printouts, etc. And three, it also goes on to say something, which is that you don't even have to give electronic copies of the entire record seized. It would suffice if you give that copy of the portion which you intend to rely on. That brings me to the question of Mr. Om Prakash, which is how do we know whether the copy that is submitted to the court is the same as the copy that is given to us? There are two ways you can find that out. The first thing, and this is something that the person who is submitting the copy is expected to comply with, which is to provide the hash value. A hash value is nothing again except cryptography, right? All it does is you have a document which could probably run to 100 pages, etc. Everything is hashed into a small number, which is like a fingerprint. It will not change provided the contents have not been modified. So, for instance, if a document is opened and reopened and closed, chances are the hash value will change. That doesn't necessarily mean that the contents are different. It is just that whenever a hash value, whenever a document, electronic document captures metadata also of the logs, etc., then automatically it is also creating a hash of that modified document. It doesn't distinguish between the Word document which you created as your agreement and the metadata, right? So it is giving you a hash value of the entire record. And therefore, there are chances, and therefore, again, I'm qualifying it. That's why that merely because a hash value varies does not mean that they are two different documents or that it cannot be relied on. So to answer your question, one is a hash value which can be utilized, and the other is a simple search and inspection and discovery process where you verify apples to apples. There is a third aspect, which is what I've used in many cases also, which is to rely on transcripts. So if I'm producing transcripts, even of the electronic records which are submitted by the other side, and if the other side is not contesting the veracity of the transcript that I'm relying on, then that is something the courts have referred to and relied on without having to spend many hours of having to watch the video. So we as lawyers are very innovative, and we also keep evolving with processes, but there is both a technology as well as a legal and simple process in terms of proving the veracity of both documents. So moving forward from 207. Remember that when we talk about a trial process, everybody believes that by raising a presumption of doubt, it is sufficient for a document to be thrown out. One thing which I keep emphasizing always is this, that, and again I would take the example of a paper document. Paper documents also could be forged. That did not stop us from relying on them. Similarly, electronic documents, of course, can be forged. I have had cases, I have dealt with cases where emails were fabricated. But what they do is they use ingenuity. So all that you would have to do is to, keep your antennae up to ensure that you verify to see whether both sides, in this case, what we did was, and nobody picked it up, that the email was modified. What the person had done was they forwarded the email, and in the forwarded mail, because the email which is received cannot be edited. So what they did was, when you forward the email, you can actually edit it. And in that forward, it was not just a matter of deleting one or two words, but whole paragraphs were either deleted or added, merely for the limited purpose of putting forth that person's case. Now, when you compare the email which is received by your complaint from the email sent by somebody else, then you already have a methodology of proving that the document that is received by somebody else is fabricated. A few more pointers with respect to relying on emails. Now, it's very interesting. We have to remember that there are various means and methodologies for masking email IDs, to the extent that today you can receive emails as if it is from napenai.com, and I would not have sent it. So when you do this process which I'm talking about, that does not necessarily mean that whatever you see is 100% right, and that therefore you can, you can safely say, no, nonsense, but that she's saying that she didn't send it. Of course she has sent it. My suggestion is, please dig deeper. So let me do a little bit of a screen share again for you all. Yes. So when you look at this document, which I'm just putting up, you will see it's not very readable. I'm sorry for it, but if you can, I'm just putting it up for a kind of a visual recall, and for you all to know what I mean when I say that. And I'll try and just point here. I don't know if my cursor is visible for you all, but that's what I'm trying to do. Just point to what you should do. All you have to do whenever you are trying to rely on an email or contest it is, go to the full header of the email. In all probability, before you even take a document to forensics evaluation, you will find your trail. I call it in my book, Electronic Evidence, the breadcrumb trail. And I have relied on Hansel and Gretel here to say that electronic evidence is always like that. The trail is always there. But sometimes, not always, but sometimes the trail may disappear. So the best thing to do with respect to electronic evidence is always get the trail first, follow it through to its finality, and keep everything ready, because then at the stage of trial or subsequent proceedings, it just becomes that much easier for you. So when you're relying on an email, always read it bottoms up, not top down. because the story of the email, the trail of the email follows top down. It will first start with the person who has sent it, then where did it go, what is the path, what is the IP address, who has received it, what is the return path, what happened thereafter, everything. So when you read it down, bottoms up, you will substantially get a lot of information that will help you in understanding the authenticity and integrity of this document. So the trail is already there for you, and all you would have to then do is follow through with, let's say, an IP address to find out whether it has emanated from the person who it claims to be from. In most instances, you will see that even with respect to phishing mails or mails where, some fraud is meant to be played, or for that matter, even a prank email, you will be able to see the path and the trail. Similarly, when we are talking about, let's say, messages, there was one of the earliest cases I came across was an argument in the case of a famous Bollywood actress, as she was then, who had filed a case against an agent of threatening her. And she had relied on certain SMSs in that. Now, when the bail applications were being argued, anticipatory bail applications, all that the accused had to do was to show that you could use something as descriptive as fakesms.com to fabricate an SMS and make it seem like it came from my number to yours, so to say, right? And with that demo, they were able to get anticipatory bail. One qualifier I always put to people here is, we could have easily proven in every proceeding that has happened in all our years of practice that a paper document could be fabricated. Would that alone have helped us to get orders in our favor? Certainly not. Because probability is not enough in these circumstances. We would have to show probability not as a general probability, but probability with respect to this case. If the trail of evidence that had been produced by the accused in this case had been, let's just give an example, his telephone records, which would have shown that the records that have been captured in an automated form and which is being stored in a third-party server, therefore it is not amenable to tampering by the accused, shows that there was no message sent on the date and at the time when this message is reached the recipient, and therefore things like fakesms.com could have been used. I can understand that argument of probability, right? Because we are able to show the trail. So I'm using this example for two reasons. Whether it's a WhatsApp message, whether it is an SMS, etc., you can fabricate a message as if it emanated from person X or Y. One of the earliest apps that came out for this was in a Samsung Android phone, where you need not even have complicated technology. All you had to do was just have access to somebody's mobile number, and you can immediately have the fake messages sent out. You can, with a slightly more complicated technology and with your numbers in hand earlier on in advance, even have WhatsApp messages intercepted and modified. Okay, not just fake messages, but modified. So there are trails again everywhere in terms of how you can find out whether the message that is received or sent is genuine or not. The very first stage, like I told you, is the paper trail, which can prove it. It can also be collected from the devices. Because let's say a WhatsApp message and everybody will throw this word at you, oh, it's end-to-end encrypted, right? End-to-end encryption happens in transmission. So when you are generating a message in your device and a person receives the message in their device, both of these parties do not have it encrypted on their devices. So this content is very much available for access and receipt. Again, here is a trail for you. When you go to your WhatsApp message and you right click, you will get all those details about those, information of reply, forward, etc. A fake message will not allow you to forward it. Forget about the restrictions WhatsApp has brought in today that you can forward it only once. Here, it won't even have that option. This is another way that you can find. So these are all simple forensic tools which help you to know the trail without having to get into the next level of cyber forensic experts coming into the picture. Of course, you can rely on them, but you don't have to necessarily rush in until you know otherwise. So there are many methodologies. And the reason why I mentioned about the device having the content is there are many cases, and some of the most interesting cases come up from income tax violations, where when a raid is conducted or, when there is apprehension of a raid, mobile phones are one of the first to be destroyed. So in one case where it was completely destroyed, the department through its forensics, process was able to retrieve data even from a damaged phone. So merely deleting a message will not get rid of it. It may still be very much available for you in your device. Same is the case whether you're dealing with a computer or any other electronic device. So one is, unless it's overwritten, it is available for you and you can retrieve it. Damage does not necessarily mean that your data cannot be retrieved. So end-to-end encryption or not, by relying on retrievals from devices, it will still be possible for investigations to show whether something like a threat message had been shared or not. So that's the next stage which I wanted to address in terms of electronic evidence and its authenticity, etc. So are there any questions? I know I have been going on for a while and I will be moving shortly. I realize we have finished about 50 minutes into the session. I had a few issues I wanted to cover before I move into the all-important section 65B. Is there anything that any of you would like to raise as a query in the meantime? Would you like to share on chat the queries that you may have, so that in case, we don't have too much time later, I would still be able to look at the chat session?
Yes, madam, you can go ahead with your session. So as and when some queries comes, let them share it in the chat box. So let us have all the queries at the end. So
then may I request that you please bring it to my attention in the event that some question is put forth in the chat session, so that I do not miss it, and I will definitely try and address every single question.
Because in queries, normally we will not be clear about what time it may take, depending on the answers it may get along. So let us complete the session and answer all the questions.
Absolutely. So again, like I said, let's start at the beginning with respect to when we come to proving of electronic records, etc. Okay, so before we go into that, just a little bit of an aside here. So what I was talking about as a breadcrumb trail, we covered emails, we covered messages, etc. Similarly, there are very interesting cases which I've dealt with, which refer to the internet history. Now, most people don't realize that when they use a browser and they send emails, even using personal email IDs, where we may not have access to those personal email IDs, and we here being corporate entities, using the tools available. So you need a software for this. The simple process of just reading a header will not be sufficient for retrieving internet history, unless, of course, it has not been deleted. Now, when you have to retrieve internet history, you will find very, very interesting information that comes from that. So whenever I talk about electronics, I always refer to it as a treasure hunt, because you just have to know where to look. You have to know what are the clues that have been left everywhere. Once you know the trail, then it is very easy for you to find evidence which will substantiate your case. So here is the trail that you will find. So this was a case where one employee had already served notice of termination, and during the notice period of 1 month, a lot of proprietary source codes Not just general text-based information, but actual source codes were attempted to be transmitted through a personal mail ID. Now, the issue here was that the attempt is for transfer to a personal mail ID, which we don't have access to. We got information from, and this is what I always tell people, look at audit reports, IT audit reports. Every company, as a matter of process, will have regular IT audit reports. So the minute you look at IT audit reports, you will realize that a lot of information comes out from those reports. And the trail and where to look for further to substantiate it will also come from there. One was a very interesting case where, using a company email ID only during the notice period, this person had sent proprietary information with respect to the customers and their personal information by email to his personal email ID, and calling it as, oh, my hard work. So in many instances, people genuinely believe that, they're entitled to take away data like that. I wish that there would be more awareness programs in corporates, because that once they know what is a crime, there is a possibility that it would be a strong deterrence for most people to not commit this crime. In another instance, a top management person uploaded it without realizing it was a public FTP. So when you're putting it online, and unless it's a private domain, storage domain, it is accessible to everybody. So because of this violation, very sensitive business plans and proprietary information of a company was violated. So there are many, many ways in which people violate. There will be instances where companies in early days were very lax in terms of changing of passwords, etc., including for emails for a period of time, because their policies in those days would be emails will be changed every 15 days, etc. So if you are leaving either at the beginning of the 15 days or midway through it, you have a window of opportunity within which you can still play havoc. So there are so many cases with respect to data theft, and predominantly corporate cases invariably deal with this, which address these kind of issues. So that other case which I was talking about, we found the trail with respect to the transfer or attempted transfer through internet history details, which we were able to cull out. In that, what we were able to show is the date and time of the emails, to whom and from where and to whom it was sent, of course the IP address, etc., but also the subject line and the description of the attachments. So using that to correlate it with further documents retrieved and submitted in evidence from the defendant's side, we were able to show both in the civil proceedings as well as in the criminal proceedings the attempt of data theft. And here, since the transfer was done and that it didn't, the accused or the defendant did not receive it because of other reasons beyond her control, it was still an attempt that stood fructified. So these are all interesting trails which help you to easily rely on electronic evidence. And like I started off, and I would like to just remind you all here, unlike paper documents, where unless somebody gives evidence of when it was created, who created it, who sent it, how was it created, etc., here, at least to the extent of a device, if not the person, you will be able to track it and trail it back to the culprit. A very interesting case again where, a very big transaction and negotiation is happening between two fairly large parties. Middle of that, suddenly the negotiations take a turn for worse. Now, this person who thought he was going to get a good deal out of this negotiation is very surprised about why should it take a turn for the worse. And then he simultaneously starts getting messages from his Gmail account about changes in passwords and retrieval email IDs and whatnot. Thankfully, because of the multi-factor recovery process, he is able to take control of his Gmail account again. And what does he find out? He finds out that most of the mails that have been verified pertain to his banking transactions. So once one negotiating party knew the financial position of the other, they believed that they were in a better position to modify the terms of negotiation. So this is how easily something like a simple case of hacking can be misutilized. And we are talking about several thousand crores worth of negotiation here, not even a small negotiation. So a case is registered and the police curiously track it to the secretary of the MD of the company. Now, when a trail is tracked to the secretary, the case is registered in the name of the secretary instead of the company or the MD. The issue that arose was, will this not amount to an offense by a company? And where in the Information Technology Act, there is a deeming provision for holding the company as well as persons in charge of responsible or who conspire or connive to commit an offense also liable. So in such circumstances, we contested the fact that the FIR was registered only against a person, what we say in Tamil, right? So we say about the bow and the arrow. It is not about the arrow, it is about who dispatched the arrow that is relevant. So what we were asking for was the person, right? The person who actually dispatched the arrow to also be held liable. There was an interesting case which of course resulted in a settlement, but I'm just referring to this to show that the trail here led to a device which is being attributed, the linking to person again. So that 4 things which I told you, which were only meant for issuing secure electronic signatures, I can tell you can become the mantra for you with respect to proving of electronic records of any form, in any manner possible. So when you talk about the cases like this, the linking to person happens with respect to whose device was used and who stood to gain out of these proceedings or the commission of an offense. So once that is there, the deeming provision can be invoked, and in many instances, that is why data theft cases will also have the names of the companies which this person, a former employee may join. But it is not like every case can or should impute the company. Because if a person has committed a theft when nobody asked him to, and that data is anyway not relied on by anyone, even with it merely being found in a device in a company cannot necessarily impute the company. Moving forward to the next step. There are very interesting cases that keep coming up in terms of what is an electronic record. So there was one case before the Bombay High Court with respect to, is a digital photograph an electronic record? You will find the answer to all of this to a substantial extent in the case of Jisal Razak versus State of Kerala, 2019 SEC Kerala 3164, where they talk about all the kinds of documents which will amount to an electronic record. So in a recent session, somebody was talking about the boarding passes and how those are also printouts, etc. Yes, of course they are, and therefore you will have to necessarily comply with 65B4. So now I will definitely move forward to the all-encompassing 65B4 aspect before we open it out to Q&A. And I will not take too long in terms of interpretation, etc. I would like to stick to the practical aspects of how 65B4 has to be applied as it stands today. Instead of just limiting our discussion today to the very intricate and complicated aspects with respect to Anwar versus Bashir and the Navjot Sandhu before that, and Shafi Mohammed and Arjun Pandit Rao, etc., and many, many cases in between. The first and foremost, there are innumerable judgments, including Anwar versus Bashir, which make it very clear that 65A and 65B, by their very nature, by the very wording that is used there, only refers to copies of documents, electronic documents, when you wish to rely on the same before court. If you're producing the original, then it is only the original which matters and not a copy of it. Sundra Mohan had raised this question earlier in terms of what amounts to an original then. Because when you talk about electronic records, interestingly, even at the first level in terms of a creation of an electronic record, you have a temporary file created and you have a permanent file created, and many copies will exist simultaneously. Even when you're taking a printout, for instance, you may know the device from where you're taking. Sometimes you may not even be aware of where exactly it is stored in the electronic form. So if you look at the one provision in the 65B, which is sadly missed most of the time, which is 65B3, you will find your answer to that. So, I was part of the government committee which was given the task of evaluating recasting 65A and B, or deciding on the provisions that should apply for taking on record electronic records. Of course, my submission on that, I do not know where it stands today, because we have completed and submitted our report, but we don't know where it stands today. The first thing I had suggested was 65B definitely has to be scrapped, and 63 and 65 are fully sufficient to meet the requirements of secondary evidence, including for electronic records as they stood. Worst case, if at all you felt there was something lacking in that, things such as this 65B3, which is what most people do not talk about, ought to be included in 63 or 65 to make sure that this aspect about original stands clear. So Mohan, for you, and of course for others, what you're really trying to prove with your printout is that it is a true and correct copy of the electronic record of which you're taking the copy. So for instance, if you have something on your computer, and then you have a CD, and then you have a printout from the CD. So your 65B certificate will be given not only with respect to printout from the CD, but also copy from the computer to the CD. And broadly, you will get this guidance from Ramajayam's case from Madras High Court. So one, the reason why 65B stands on a different footing from 63 and 65, I would say, is in this aspect, which is that it recognizes the feasibility or the possibility that multiple originals can exist at the same time. And each of these electronic records are effectively treated as originals. And when you're giving a certificate, really speaking, you're giving that certificate only with respect to what you're giving this copy, or you're taking this copy from. When you're taking it from a copy and not the original, you're also opening yourself to repudiation of the documents or the details that you're relying on. And therefore, Ramajayam takes it forward to say, when each step is covered, then you have successfully completed the chain of circumstances which lead only to the assumption that this is genuine and authentic. So one, that a computer will create multiple originals at the same time is already taken care of under 65B3. So therefore, you do not have to worry about will that be contested as a copy. This is like, in civil law, we say when multiple agreements are created and each counterpart is an original in itself, similar to that with respect to electronic records. Moving forward to the other two aspects. So you had raised, Mr. Badrinath, sir, you had raised this issue about whether the Supreme Court has now done away with 65B4 certificate itself or not. In Anwar versus Bashir, the first thing is, and very unequivocally confirmed, and I believe it will be confirmed going forward also in Arjun Pandit Rao, going by the arguments that were submitted before court, an original does not need the certificate. It is only when you're relying on a copy that you need a certificate. The second aspect of it is that Anwar versus Bashir very unequivocally laid down that you cannot substitute general laws with special laws. Now, Navjot Sandhu said that you can rely on 63 and 65, and 65B4 was only optional. The reason why it interpreted it in that manner was because of the wording used in 65b4, which says that in any proceedings where it is desired to give a statement and evidence, by virtue of this section, a certificate doing any of the following things, that is to say so and so, and purporting to be signed by so and so, shall be given in evidence of any matter stated in the certificate. And for the purpose of this subsection, it shall be sufficient to say that it is given to the best of knowledge and belief of the person who is giving it. Now, when they interpreted this, and if you look at the wording of 65b4, I tend to tilt towards Anwar versus Bashir to say that the fact of special overriding general is probably correct, and therefore the certificate is necessary. It also actually is meant to make your life easier. If you were to go under 63 and 65, the issue we just spoke about of what is the original also becomes an issue. Since electronic records have this flexibility of multiple copies being there in multiple places, one of the things that 65B ensures is that you do not have to worry about whether it's a photocopy of a photocopy, which will then be struck down under 65. You will still be able to rely on. You do not have to issue a notice to produce. All of these things have been done away with, and which is why I started off by saying nobody meant to punish us by bringing in 65b4. It is purely with respect to a special form of proving of secondary evidence, and which is why I have qualified copies proven through 65b as special secondary in my book on electronic evidence. So when you talk about copies now, the first question that will always arise is, okay, let's just complete the Anwar to Shafi to Arjun Panditrao first before we move to who, what, where, when, why, how. And that is the part which I would like to really focus on more here. So when Navjot Sandhu said it was optional and Anwar said, sorry, it is mandatory, it said it because 65B and 65A made it a special provision very clearly and unequivocally for electronic records. The real issue that arises with respect to Anwar versus Bashir is the manner in which 65B4 has been interpreted. Unfortunately or otherwise, I see that the Arjun Panditrao bench may also resort to the same or similar way of interpretation, which is when you look at 65B4, it uses two NEs, not one, but two NEs. The first, it says that if you wish to rely on an electronic document, any of the following will have to be complied with. The first is to identify the document and to show that it has been created as a computer output. The second is to identify a device and show how it was created. So if it is through automated processes, then you have to identify what is the device used and how is the automated process functioning, and to prove that you can rely on this document. Primarily, the reason being that you are still showing that authentication and integrity process. The third out of the NE is that you can rely on, again the second NE comes here, you can rely on any of the conditions laid down in 65B2. Now, when you look at both NEs, the Supreme Court seems to be veering towards reading both of it, which is what Anwar versus Bashir did without much discussion on it, of interpreting both NEs as all. What they did was they said you have to prove all of the following. And the way they interpreted is two of the subsections in 65B4, which is identifying document and device, and four of the conditions under 65B2, which is to show that it is a computer outfit, show that this is a computer that has been utilized in the ordinary course of business, that it is functioning properly without any disruption or damage, etc. And the fourth category, which to me reads almost like a reiteration of the first three, it merely says information contained in the electronic record reproduces or is derived from such information fed into the computer in the ordinary course of business. Effectively, 4 merely says that this is the copy that you're producing and it is the same as the original. Now, Where I feel that the Supreme Court may be missing the point over here is, and this is not raised or addressed or an issue pointed out either in Shafi Muhammad or Arjun Pandit. Can both NEs in section 65B4 be treated as and? If both cannot be treated as and, then what exactly is it that the legislators intended for a person to prove? There is one very important aspect of 65B2 which may again give a guidance. And this is the one thing which I've said both in my book and in fact, thanks to the persuasion from Justice Kurian Joseph after a session at the National Judicial Academy, I wrote a very detailed article on this for SCC. I'll give you the citation shortly, but that's a cited journal article in SCC. Now, what I have pointed out is that the first part of 65B says that if you comply with the conditions in section 65B, then the copy is deemed to be a document. Now, those conditions could have been anything which is in 65B2 or 4. Unfortunately, in 65B2, the wordings are also again reiterated that these are the conditions you have to comply for as set out earlier. So in that sense, when we look at Anwar versus Bashir, we can definitely assume that possibly they meant for everything to be, all 6 criteria to be complied with. But in that again, I would say that 65B2 has to be interpreted a lot more carefully, because if all 4 conditions under 65B2 are read as and not just the last of it, then except for documents which are in your own custody, it would become next to impossible to prove it. Of course, the way out is given also in Anwar versus Bashir. They go on to say that one certificate has to be given, but they go on to say that it is enough if it is given to the best of belief and knowledge. Again, in Arjun Pandit Rao, the Supreme Court seems to be veering towards this in what they mentioned. So when we talk about these 2 cases, all that happened was in Anwar versus Bashir, they just talked about these 2 aspects. One is with respect to 65B4 being mandatory, and 2, that 65B4 should comprise all 6 conditions, and 3, it is enough if it is to the best of knowledge of the person giving it. They did not mention who should give. A lot of, and they also did not do a prospective overruling. So all cases between Navjot Sandhu and Anwar versus Bashir were affected. So a 2-judge bench of the Supreme Court in Sonu was a state of Haryana went into this aspect, and they brought in a very simple methodology. Again, standard first principles for us, that procedures are only handmaids of justice. And they said that any technical violation with respect to 65B4 was curable. Therefore, at any stage, you can cure the defect with respect to giving of the certificate. In that specific case, they also went on to say that if a person has not raised an objection with respect to 65B4 at the stage of trial, they will not be allowed to raise it at the stage of appeal. This has been subsequently upheld in many judgments, including up to 2018 in Ravindran versus State, etc. Rajendran or Ravindran versus State. I will provide you the citation also in the list. Let's now come to Shafi Muhammad, and why I am saying that even Shafi Muhammad does not do away with the section 65B4 certificate. All that Shafi Muhammad did, which was a 2-judge bench as opposed to the 3-judge of Anwar versus Bashir, was that they said that Anwar was very much correct that you have to give the certificate. However, you only have to give the certificate if the document is within your custody, either as the author or the recipient. If the document is in the custody of third parties, it is open for you to rely on 63 and 65 to prove that document. So by distinguishing instead of overruling, they tried to overcome this issue of 2-judge bench deciding on an issue decided by a 3-judge bench. There were issues even with Shafi Mohammed. So therefore, sir, they did not do away with the certificate. They only distinguished it for certain purposes. The other issue that came up was parties could not decide of their own accord that, okay, this document is in the custody of a third party, so I will not give a 65B4 certificate. They said that the discretion on whether the certificate was needed or not will lie in the hands of the court. So the problem that I see with that, and which is what I mentioned in my article also, is that when you leave it to the discretion of court and that discretion carries no certainty, everybody would just err on the side of caution and just give a certificate. Whether it is Kundan Shah, Paras Jain or Ramajam's case up immediately after Anwar versus Bashir, or a multitudinous cases thereafter, all of them give some pointers with respect to who should give the certificate, when should it be given, how should it be given, and how it can be relied on, etc. So what they did was effectively they tried to plug the holes left by Anwar versus Bashir. One of the finest in terms of its interpretation is Ramajam's case of Justice P.N. Prakash from Madras High Court, where it went into these aspects, which is what I had highlighted in the beginning itself, that merely because a document can be modified does not mean that it has been modified and that therefore it should be rejected. So they said that, so criminal process should not suffer where, for fear, we will allow criminals to escape. At the same time, we have to exercise caution when we are handling electronic records. They also went on to say that any person who is in control of a device or the administrator of the device can give the certificate, and any service provider also can give the certificate. The issue then arises, who is the owner or the administrator of a device? Now, all the judgments that have come this far only refer to one part of B4, which is the control over the device. What they have not addressed is the control over the activities. So there are two parts to 65B4 proviso, which says any person who's the owner of a device or has control over the activities. So when we talk about criminal cases, for instance, there is no way that an accused is going to give you a 65B4 certificate. And you are recovering your data from the accused. We will face similar situations where certain recoveries may be done from the defendant in a civil case or from parties and before tribunals also. There are many cases that have arisen, for instance, from family courts, where, again, as with tribunals, strict rules of evidence do not apply. In many instances, the courts have waived the necessity for a 65B4 certificate. In several other instances, they have taken a very relaxed view with respect to who can give the 65B4 certificate. So when you take it to a practical consequence, especially when we are talking about documents which are in the custody of third parties. One example, simple examples here. Many of our cases rely on social media posts, right? So authenticity or integrity of the contents is a different issue, and I'll come to that after we finish the 65B part in terms of what does it prove. But when we talk about relying on a social media post, and I have dealt with a lot of cases of cyberbullying, cyber stalking, etc. Very, very scary cases of sharing or uploading of morphed pictures or revenge porn. And the case, of course, which I'm dealing with as amicus before the Supreme Court, which speaks of child pornography and those horrific cases of uploading of rape and gang rape videos online. We are now talking about data which has been uploaded by a third party, which is residing in a third party's domain, and we wish to rely on that. Who is going to give the 65B certificate here? So the simplest route to the 65B certificate would be the person who is creating the copy. That person will be able to speak to the source and the document, and very emphatically and reiteratively the Supreme Court has held, all that is needed is to the best of knowledge he may not know beyond that, but to the best of knowledge. And the second part becomes important here, which is, what is it that you're proving? That from the time of its creation to the time of you making the copy, it is working properly and that the contents remain the same. Now, when you're relying on a social post, the post will show when the post was created. And to the best of your knowledge, if it has not been modified, it is sufficient for you to prove that. So the person taking the copy could be the police, it could be a forensics expert, etc. There are a lot of ingenious ways in which criminal cases are being dealt with in this aspect. And it could also be the complainant who downloads and takes a copy and submits it. As I told you, if we go to 3 and it talks about any copy and multiple copies of it, etc., forming part of the same trail, and if you're also relying on a copy from a computer resource, it is that computer resource from where the copy is made that becomes relevant. And therefore, the middleman with respect to various other copies, etc., gets cut out. And this is the practical way in which it has been applied with respect to who. Otherwise, it is a straightforward case when it is a document which is in your custody, and it is a very easy procedure to comply with to show that this is a document which is in your custody, that it is a computer output, that it has been created in the ordinary course of business. The phrase ordinary course of business has also been interpreted to just mean in regular usage. It doesn't have to be a commercial transaction as an ordinary course of business. And that it is, that the system has been functioning properly without disruption or delay, or that even if a disruption or delay was there, a disruption or damage was there, it did not affect the integrity of the contents. So with that, effectively, we come back to the Shafi Muhammad stage, where it tried to create this distinction of using both 65B4 as well as 63 and 65. Now, when the Arjun Pandit Rao case, which is a civil appeal, was taken up, they referred it to a larger bench by saying that Shafi Muhammad's decision is of a 2-judge bench. And today, with every single legal proceeding needing the reliance on electronic records, it is important that we are allowed to have certainty. We need certainty with respect to reliance on electronic records. Unfortunately, the fact that a 3-judge bench has been constituted indicates that somehow the reference has been interpreted to seem as if it is only with respect to Shafi Muhammad and whether it's correct or not. But really speaking, when you read the reference, it is actually for everything with respect to Anwar versus Bashir also. So ideally, it should be a larger bench which is hearing and deciding this. And what we really need certainty on is these aspects. If 65B4 is mandatory, and my interpretation is yes, it is mandatory. It is not left to the whim and fancy of a person, because that can play havoc with respect to reliance on electronic records. It's actually an easier option which they are trying to give us. It may seem strange, I'm saying it, but believe me, that seems to be the intent and purpose behind it. The issue would be with respect to what are the conditions that have to be relied on. Do all 3 of the conditions under 65 have to be relied on? And do all 4 conditions under 65B2 also have to be relied on? This will be a very important issue that will have to be decided. And such a decision can be done only by a bench which is larger than the 3-judge bench. So it will have to be a 5-judge bench to decide. The second issue that will have to be decided is who has to give the certificate. Because if it is to be interpreted only as the person who has control over the device or the administrator, then again, most of the documents cannot be relied on if all 6 conditions have to be complied. If it is some of the conditions, then it will also give clarity in terms of who the person will be. If it is all of the conditions, it is going to create further churn with respect to who will be the persons who have to give this certificate. In that, my guidance note would be to see both aspects, which is control not just over the device, but also active. The next stage is to the best of knowledge and ability. All courts are very clear on that, that is a very, very low threshold of proof, and that is all the law has mandated, and therefore it cannot go beyond that. There's a very interesting question that comes up, and which is why I worry about this excessive focus only on 65B4 certificate. Everybody, because it's such a difficult threshold to mount because of all these complications, most people think that with the acceptance of the document as an exhibit, the job is over. Unfortunately, all that 65B4 does is it only allows you entry into the threshold. You've only crossed the first stage in the trial, which is for the document to be accepted. The contents, the truth of the contents in the document still has to be proven. And this comes from the judgment of the Bombay High Court in terms of Jaimin Jewelry's case. And this is not just Jaimin Jewelry which says, again, all we have to do is go back to basics and we get the decision from that, where it says that you cannot, or even that authenticity, integrity, and the words used, contents of the documents is only the integrity of the contents of the documents, but not the truth of the contents. The citation of Jaimin Jewelry is 2017 SEC Online Bombay 1771. So when we move on, therefore, once you have crossed the threshold with respect to acceptance of an electronic record, this is why I said forget about this prefix of electronic, because we have come back to basics again in terms of how are we going to prove the truth of the documents. Even this case which I mentioned to you, sir, of this family court's judgment, that is what they say, that the 65B4 certificate is waived, and they say yes, we can take it based on 14 of the Family Courts Act, but that alone does not mean that we will allow for the contents also to stand proven. Since in that case the contents were not proven, the case was rejected. So today, where do we stand? Unless otherwise decided in Arjun Pandit Rao's case, and that cannot be done by a 3-judge bench, because the 3-judge bench's only option is to affirm Anwar versus Bashir. We have to assume Anwar versus Bashir is correct and go based on that. We will have to comply with all 6 conditions to be on the safer side. But with the qualifier that you would only have to prove that which is to the best of your knowledge and ability. This certificate does not have to be given either at the stage when you're filing a plaint or a complaint, etc., not during investigation, not during charge sheet, etc. It may be preferable if it is collected at that point of time, but if it is not collected also, it doesn't matter. It would suffice when you give the certificate at the stage of giving evidence. Now, going further, what happens in most of the cases which I've dealt with is that the certificate will be either collected at the stage of charge sheet or when evidence is given. But the certificate will say that, the computer is working fine today, and that the document, has been taken from this source. Now, what the printout that is being relied on was collected at the stage of investigation, not at the stage of trial. So what your certificate has to cover is the authenticity and integrity of the document with the original source from the time of its creation to the time of the printout. It doesn't help or further your case if you're going to rely on it in terms of what is the status of the resource today. Finally, the Ravindra Desai case, which is what I had mentioned to you about earlier, the recent Supreme Court judgment, talks about how even if there is a difficulty with respect to the production of certificate, etc., it is a curable defect and it can be done at any stage. Therefore, if the issue is not raised in trial, then SONO applies and they cannot be raised at the stage of appeal. And when it is raised as an objection also, it is open for the parties to produce that 65B4 certificate. There are many CBI cases which have been decided by various high courts where a 65B4 certificate is given and it is also rejected. Now, when that kind of a situation happens, the issue arises in terms of what do we do? How do we deal with that situation? Does it mean that the document itself has to be rejected? Not necessarily. It again, the curable defect aspect comes into play, where in one of the judgments, the courts also go on to say that even where the certificate is rejected on a technicality, it was open to CBI to submit a further certificate. Knowing that a 65B4 certificate is needed, where CBI did not give the certificate, the courts held that it cannot therefore do away, it cannot overcome this technical problem. And the case was rejected on that basis. So, going into all these aspects, you will see that one, the evidence proving process. What is it that we would do when we were putting together our case? We would invariably look at the chain of custody as the primary focus. We would see authorship, recipient, what was the chain of custody of this document, and prove every link in that chain. We would establish circumstances to show the authenticity and integrity of the document, or the contrary with respect to contesting the authenticity or integrity. Beyond the authenticity and integrity, we would still have to prove the correctness or the truth of the contents in the document. Merely because a document is marked as exhibit does not mean that the contents also stand admitted, right? So with all of these, we actually come a full circle where we realize that there are certain enabling provisions which have been added through either the Information Technology Act directly or through amendments from its schedule to the Indian Evidence Act. Both of these read together are meant to be enablers and not obstacles. If we approach it in that way, and where courts are taking a practical view so that, as they said in Tommaso Bruno's case, that best evidence is not ignored, then we come to a situation where we will see that despite all these complications with respect to the language used in 65B or with respect to any of the other aspects, we will be able to effectively use electronic records in proceedings. Thank you all, and now I hope we have time for questions, and I'm happy to take them.
Thank you very much, madam. There are some questions which have come in the chat box. I think Shiva will take you through that also, and any person who wants to raise it also, we will have it now.
Absolutely.
There is one question which I can just put it across to you. Yes, go ahead, sir.
Yeah, that's one question from Suganti. What is the cost of forensic data search? How does the electronic evidence play a role in copyright violations in the digital age and the digital publication in multimedia?
Well, very interesting. And yes, it is a very, very relevant aspect. One, cost is subjective. It depends on who's the forensic expert that you are using. There are many, many of them out there. There were two other aspects which I wanted to cover, or at least one, and I'm glad this question came and I can address that. One of the things which is really causing serious concern in me is the addition of 45A in the Evidence Act and 79A in IT Act. Now, 79A introduced this office of an examiner of electronic evidence. 45 is for expert witness, and 45A was introduced as, the examiner of electronic evidence being treated as an expert when it comes to digital records or electronic records. When you look at it in this manner, there are only about 6 or 7 of these forensic experts who have been notified as examiners under 79A. It just creates a monopoly. Whereas we had 45, which was more than sufficient to permit the use of cyber forensic experts as experts in a proceeding. So this is an issue which still hasn't been subjected to judicial review. Whatever cases, if you come across, you will see that there will be quite a few which will talk about 79A and 45A without going into this aspect that there is literally a monopolistic practice when it comes to forensics experts who are actually certified under 79A. So we will have to wait and watch. I keep saying that if Anwar versus Bashir is to be applied, special overrules general, then does it mean that we cannot rely on experts under 45 because 45A has been added? Because they also use the word only in 45A. Until such time as further clarity comes on that, let us move forward. One, there are many digital forensic experts, but please do your due diligence before you engage them. Verify what is their credentials and to what extent are they going to be able to help you prove the trade. Once you engage a forensic expert, you should be able to ask the right questions. It's always the same. That is why I said nothing changes with respect to our roles as lawyers as we knew it earlier also. Nothing changes. So you have to ensure that you ask the right questions to make the digital forensic expert look in the right direction. If you do not give the correct parameters, then your outcome or the report may not be very relevant to you. If you're talking about a copyright violation, now there are many aspects that come into it. I do not know whether the question was keeping in mind online copyright violation or software copyright violation or violation of such another kind. Invariably, in most of the data theft cases which I was talking to you about, they also deal with the aspect of copyright violation, right? Especially the cases I told you about, the source code thefts, etc. Or it could be even through reverse engineering. In most of those, you will have experts coming in to give evidence, and it is very important. You have to know the domain, especially when it comes to cross-examination of those experts, especially when it comes to copyright violations with respect to software, etc. Some pointers here. Most people forget that there may be certain aspects which will be similar between two documents. And you have to distinguish between the language that is used or the source codes for language or the software program for which is a standard commercial product as opposed to the proprietary or the customary code. So you will have to look for that digital trail which will show you whether in fact the report is fudging between or does not take into account the delineation between proprietary software programs as opposed to general product codes where everybody is entitled to use it. So this is for offline processes. If you're relying on online processes, most of the other aspects which I told you about in terms of following the trails through internet histories or IP addresses from where a link has been created, etc., will come in handy.
Okay, the second question is from Suresh. Can a deleted message and call logs of a mobile phone be retrieved by forensic department?
Absolutely, they can. In fact, I had mentioned earlier also with respect to the IT cases, etc. One, you can retrieve deleted messages also. And that is why you can still rely on WhatsApp messages also once you have the mobile device to retrieve this content from. The second aspect is you can retrieve even from a damaged computer resource. Many times, and this is where it becomes a little bit more complicated because it cannot always be a yes or no answer. Which is that what happens if you have formatted the device? What happens if that content has been overwritten, etc.? So I would say the last part is what really matters. Because the manner in which a device functions is not like, you delete portion A and you replace it with portion B, it will occupy the same space. You may delete portion A, which is in, quadrant A, but your inputted information may be actually saved in quadrant 4. So it is a random access. So it is not like everything goes in a sequential process. Therefore, what may be deleted for your physical view would still be there in the device. So even when a formatting or overwriting happens, in many cases, we will find that our digital forensics will retrieve parts of messages. Sometimes the entire message may not be retrieved, but parts of it will be retrieved. So if you can rely on those parts, if the parts are sufficient enough for you to prove your case, nothing stops you from relying on that.
And the third question is there any process wherein the sender of an email can prove that the recipient has received and read the email? That is from Ashok Pati.
Yeah. So there are that will be contingent on your service providers. When your service provider gives you the option, you will find, in early days also, especially if we use browser, we could get two different kinds of messages. One is received and the other is read, both separately. But today, what is it that you are asked to prove under the Act? The presumption is, if you please look at from 11 onwards itself, 11 to 14 or 15, etc., you will get a lot of guidance in terms of, again, there is a lot of confusion in that. And well, sometimes I always joke saying that, we have, there is a reason why we have lawyers as law ministers, etc., because with all the complicated laws they come out with, they ensure that we will always have a lot of work to do, right? So it's a good thing that these things are so complicated and we are being called upon to interpret them. But when you look at these provisions with respect to originators and issuance and receipt, etc., all that it says is when a message leaves your server, that is deemed to have been sent. When the message is received in the recipient server, it is deemed to have been received. So in many cases where, we had to show, including in those data theft cases I was telling you about, we did use, the process of inspection and discovery to call upon the recipient servers to show whether this message has dropped into the recipient server and at what stage or when did it drop into that server. And if it bounced, in many instances, sometimes when you try to send .exe files, it will not allow you to send it further. So even if it is bounced, then the logs which will show that aspect. So when you look at what the law says, one, if your service provider gives you this option, excellent, because that there is nothing better than that. On this note, I would caution everybody on having these automated replies, because your automated reply, one good thing it does is it acknowledges the receipt of the mail into your server. It doesn't matter whether you've read it or not, because the attribution aspects which are covered under the IT Act says once it has hit your server, that is it, right? So be very cautious with respect to your automated messages, but that also can be used to prove attribution for receipt.
Okay, next question is from Mr. Chelli Muthu, advocate. He has raised a question. In case of an agreement executed by using digital signatures, whereas one party is at Mumbai and the other party can sign at Chennai, in such cases, where the contract is said to have concluded, either at Mumbai or at Chennai?
I would ideally say that the contract would stand concluded only after both signatures are affixed, right? But invariably, we do have jurisdiction choices, and that would have to be decided based on this aspect that one part of the execution having been completed in one place, you would have a larger option with respect to choice of jurisdiction. But broadly, for any agreement, unless and until all parties have signed the contract, is not concluded. So ideally, even recording of the facts with respect to who signed first and who signed last and what is the time, and the digital signature itself with its timestamp will give you these details, will give you the sufficient proof for showing the completion of execution.
Madam, as a request, can you give the list of citations?
Absolutely.
So that it would be easy for me to share.
I will give the list of citations by WhatsApp, sir, to you. And I will also add many cases which I may not have really gone into in detail, including the family court judgment, which I had mentioned to Mr. Bakri. It's not a judgment by the family court. It is by a high court with respect to a family court.
Yes. One Mr. Ayachami wants to raise it out. I think he has got a question.
Good evening, madam.
Good evening.
With regard to the truthfulness or contents of the document, which needs to be proved. Whether the 65B1, which says that if the conditions are mentioned in the sections are satisfied, which itself is an evidence of any content of the original itself.
Yes, in fact,
whether we again we have to prove the every content of the
you
document.
have to prove the truth of the contents of the document. So it is not just 65A. If you look at 65B2, again the same phrase is used then.
Yes, sir. Yes, that
65B2 in the beginning, preamble part of 65B2 uses the same phrase. So when you look at the judgments that have come out on this, they also refer to the exactly the same phrase, use of the words proof of contents of documents. Right? It is clearly interpreted to say that what that means is not that the contents. So for instance, just to give a very casual example, which is very evocative also, I can always send an email to you today claiming that you owe me 1 crore rupees.
Okay.
And then I can prove 65B certificate very easily because the email is sent from my server, so I will be able to show that I am in control of this computer, I am in control of my email. I can send this, I can take a printout of that email. I can give a 65B certificate proving all 6 conditions, and it will be accepted as an exhibit and given an exhibit number.
Correct.
Does it mean that you owe me 1 crore rupees? It doesn't, right? I still have to prove through other evidence that you owe me 1 crore. Otherwise, with merely a document being taken on record, we are actually obviating processes which will be about the truthfulness of it. So the standard general principles, which are reiterated in multiple judgments, have been also affirmed in Jaimin Jewelry by Bombay High Court. It says all that 65B does is only that this copy is the same as the original. Therefore, you can mark the copy as an exhibit. Beyond that, you still have to prove the truthfulness of the document.
But my aid will not come. 65B1 last 2 lines will not come aid for me. To say that
it will not, because that is already interpreted. The same language used here, which is contents of the document, have been interpreted to say it doesn't mean the truth of the contents. It means the integrity of the contents.
In view of the judgment rendered by the Bombay High Court.
Yes.
This was not in Anwar or subsequent.
No, it is not in Anwar at all. But this aspect has been argued in Arjun Pandit Rao's. So even if it is a decision by a 3-judge bench, I'm expecting them to clarify this aspect.
Okay.
Orally, the courts have indicated their mind that, of course, it only proves the integrity and not the truth. Not in so many words, but yes, it is being done. But that is likely to come as a clarification, possibly in the Arjun Pandit Rao case.
Then again for truthfulness, again with regard to that, even then we should be given with some other options or any other things, so that we are very sure, so that we should be also ancillary with some of the guidance, so that we can be also prove the originality or genuinity of that same. We may not always depend upon the expert evidence, or we may not be.
No, you don't have to depend on expert evidence always. So simple documents like emails, etc., you don't really need expert evidence for that. All you have to do is show the originator and the thing. All these are already provided for under the IT Act. So you really, and the Evidence Act. So there are presumptions with respect to originator also, right? So therefore, it is for the originator to show. For instance, if this email has come from my email ID in reverse, saying, I owe you 1 crore of rupees, right? And now the same document you can rely on, and you will prove 65B and you will put it up. Now, you don't have to prove that it was only enough this email. With that document being accepted, the originator is presumed to be N.S. Napin. I have to rebut the presumption that though it is my mail ID, I did not send this mail. So again, if we go to first principles, if somebody claims an alibi, for instance, the person claiming alibi will have to prove that aspect, right? So in that manner, here also the presumption with respect to originator, linking it to person, that's why I emphasize so much on that. The linking to person has already happened because it's my email ID.
Okay.
I then have to prove that I didn't send this message. Ayaswamy sir used XYZ methodology to fabricate this email and sent it to himself to create a false case. The onus then shifts to me. And that is how it works.
Yeah. Thank you.
Yeah, for these kind of things, you really don't need forensics. Most of the time, we use forensics more for interpreting and analyzing the underlying logs. And also where we may not be able to track the trail, where, for instance, if we are talking about a data theft case, I always keep going back to the data theft case because those are the kind of cases where you can afford a forensic expert in most instances.
Yes.
Individual cases, invariably we use what is the evidence that is available, and unless it's repudiated, there is no reason to go into an expert evidence. So in very complex individual cases, yes, we do use forensic evidence.
Yes.
But otherwise, and that is the reason why I walked you through some of the forensic processes, which is already within your custody. So you really don't need to use forensic expert. So for instance, in one case, we were able to track the IP address of a person who was defaming a company by creating a fake mail ID. And then, a former employee who was then circulating messages about the company to multiple parties.
Yes.
All that we needed was the IP address, which we got from just reading the header. We gave the complaint. The police sent the 91 notice to the service provider. And they found out that it was the IP address which was tracked directly to the former employee. That's what I was telling you. See, most people who commit these violations are themselves not experts who will know how to camouflage their IP address or spoof an IP address or create alternatives and all that. These are all possibilities. These are all things which experts will talk about. But the standard procedure is most people just do certain things without thinking about it, and it is a criminal offense or it is a violation for which a civil or criminal liability may lie. And these are all trails which are easily available for you to follow without having to resort to expert advice.
Yes. Thank you, madam. Thank you.
This marks the end of the session. Shall I just call Mr. Ashok Pati?
Hello, Nabinai. How are you?
Hi, very good. Yeah, lovely to see you all. As I said earlier, it's wonderful to see all those known faces and persons here. I've been transported to Chennai today, literally.
Okay. I thank you for addressing us on this excellent topic, and your address was unmatched. It was really good, very informative. Thank you. And I also thank all the participants who are present here. And it has been a marathon session of 2 hours almost, and very informative. Thank you. Thank you, one.
Thank you so much. Thank you all for being here.
Yeah, pleasure.
Thank you, madam. Thank you very much.